Well, hello there and welcome. This is the Disability Law Show. Good to have you back this week, or if it's the first time, tuck in. You got a lot to learn on this show. John Scholes, your host every week. And joining me as well right here, James Fireman, Tamar Agopian from Samfiru, Tumarkin, LLP. You can reach out to those two anytime you would like for a private conversation. That phone number, 1-855-821-5900. You prefer the email route, that is help@disabilityrights.ca. I'll give you some more contact information throughout the show. Things you can use, various tools as well. Our main topic for the show today is going to be Guide to Disability Benefits and Depression. Lots of stuff coming up, some of your emails. We got a lot of stuff to squeeze in 30 minutes, so we'll get going shortly. But James, you wanted to kick things off with something you wanted to talk about. Pal, what do you got this week?
So I had a lady contact me this week about an issue she was having with her insurance company. And it was, in particular, communicating with her insurer, with the claims manager on her case. And the insurance company that was supposed to be providing benefits uses one of these proprietary portals where it's not just a simple matter of you email them, they email you back. You have to go to the website and you have to log in, and then you have like a particular area where it will have your email there, but you can't access it outside and you can't send extra. It's a whole mess, and it's just all kinds of hoops that you have to go through, and you better believe that's by design. But it occurred to me that it would be a pretty good opportunity to talk about communicating with your insurance company. This is James teaches Communicating with Your Insurer 101. 101. We're going to do this very briefly. So I think it's really important because people don't necessarily understand that there are things that you need to do to protect yourself. Number one, you have to be aware of what roles people are playing. Insurance adjusters, if they're good at their job, they are going to be friendly. They are going to want you to believe that they're there to help you. That's why they spend millions of dollars in advertising to make you believe that they're your friend, they're your good neighbor, they're there to lend a hand when you're in need. I assure you, they are not. They have a job, and their job is to work for the insurance company that is doing what they can to stop paying your benefits. That's how they make money. Make no mistake about it. So you are opposed in interest to them. Understand that going in. Does that mean you should be hostile with them? No, not at all. You want to be polite. You want to be cordial. You have to provide information that's reasonable that they're asking for. But be aware that they have a role to play. And you should not fall into the trap of having casual, friendly chit-chat with them, believing that that's something that they're interested in.
Your new buddy.
It's not.
Yeah.
It's not. They are doing that simply to lower your guard, to get you to say something that they might be able to take out of context and use against you. So you need to be aware. Number two, you need to be honest at all times. You can't say something that isn't true and expect it not to have ramifications. Your credibility is critical. If you say something to your insurer, to your claims handler, that is demonstrably false, sooner or later they're going to find out, and that will undermine everything you say. If you say that you can't go to the gym anymore, and they hire an investigator and there's video of you going to your gym once a week, all of a sudden, everything that you say is tainted by that. Because if you're lying about this thing, how do we know that you're telling the truth about anything else? And this is really difficult if your disability has even an element of subjectivity to it. If it isn't something that is black and white on an X-ray, and 95% of the cases I have at least some, if not an entire amount of subjectivity involved, then that is really going to hurt you. So you have to be honest. You want to involve your doctors if there are issues with the process. So if your insurance company is, in communicating with you, causing you stress and anxiety, they are doing things that you think are inappropriate or asking you to go to treatment that you think is inappropriate, take that up with your doctor. Speak about that with your family doctor and make sure that that goes into your treatment records. So that will be there. And if there is a particular treatment that's recommended by your insurer, and your doctor says, no, you shouldn't be doing that, you want to make sure your doctor puts that in writing, not just in the records, but in a letter to your insurer. So it's in front of them. So they have to at least reconsider whether that's worthwhile. And the last thing is always reduce all communications to writing. If possible, you want to make sure that you do everything by email. A lot of insurers will push back against that and insist on communicating by phone. If they do that, take notes while you're talking with the insurance company. Take notes of everything that is said, and when the conversation is finished, send an email to your claims handler summarizing the substance of the conversation. You don't have to advocate for one side or another or provide editorial comment on what they really meant. Just provide the substance of what they said and what you said in response so that there is a record of it. And if no one disputes it at the time, then that record is going to be relied on if there's ever any dispute down the road. And as for the person that contacted me that's dealing with these portals that they make you go through, that can be really difficult. But even there, you can still capture that. You can take an image, a screen capture, or worst case scenario, take your phone and take a picture of it if you have to. But have a way to record everything that they send you and you send to them, because those portals can disappear. And that's the issue that this person was having. She wanted to log back into her portal and the communication wasn't there anymore. So make sure that you keep that and you save that somewhere where it's secure, where you're going to have easy access to it.
It's funny you mentioned that, James, about recording everything. I know there's this very simple apps on cell phones that the minute you press your phone on, it starts recording a conversation in the background. And if you got to go through it and just take notes afterwards like a court reporter, then do it.
Yeah.
Right? Because it'll be simple. Tamar, what do you think about all that?
And I was just going to piggyback on that as well, John, is that you can't assume that the insurer is necessarily recording it or preserving it or even looking at it fairly. So think about, there's some insurers now who do a transcription, actually one in particular. But the balance of it is actually adjusters who do memos. So they will, after they speak with you, they'll do a phone memo into the file. Well, that's only their perspective of what they think they said to you, what they think that you said to them, and what they think you've understood out of the takeaway from the phone call. And invariably, when we talk to our clients, there can be massive disconnects on what they understood from that phone call or what the purpose of that phone call is. Because, look, I come at this from having worked for one of these big bad insurance companies. I've dealt with these adjusters both, from the employer side and now on the other side of the fence when we examine them for discovery and do other things. And I can tell you that the advice around how you document, how you communicate with the insurer is it's imperative. But also be mindful of the fact that there's informal assumptions also being made. So, for example, if you appeal, which I'm sure we'll get to in the show.
James loves it.
It's our favorite topic. But John, I've seen people prepare 3, 4, 5-page appeal letters that they submit to the insurer when they're also asserting that they have cognitive function and they can't do their office job. I can assure you that when that appeal review is being done by that same adjuster and they review this articulate document that you've prepared, they will informally then assume that you've got a greater level of function. So just be mindful of all of it. I'm certainly not saying don't communicate. That's not what James and I are saying at all. But just be mindful of, as James said right from the start, who are the players? What's the purpose of the communication? And how do you best protect yourself when you're dealing with the disability insurer?
Give me another website as we continue on here, guys. Do I have a case? Do I not have a case? Before a phone call, even pocketdisabilitylawyer.ca is a good stop. Tamar, you like this app, yeah?
I do. I'm enthusiastic about it because it gives information out there. And I want people to have as much information about these insurance companies as possible. And so what we've tried to do, John, with this tool is really try and simplify it. No legal speak. There's drop-down menus. You can go and just find out, what are your rights? Do you have a claim for a disability matter? And we try and make it simple because we don't want people to be overwhelmed like they probably have been dealing with the insurance company. But completely anonymous, very efficient, and if you don't want to speak to someone on our team, that's totally fine. You close out the browser, you're done.
Another way to reach out is listen to our radio shows pretty much across the country with Tamar and James and myself. We do a ton of them every week. We get great phone calls. People want to know stuff, right? So we talk to them, get some answers. We like to play some of them back here. It's always a bit of a learning thing. Phone call number 1 for today's show, guys, is right now.
I worked for about 2 years. I asked for accommodation and was immediately put on short-term disability. I was denied long-term, but then given a position which I was subsequently unable to do because of my disability. I was put on short-term disability again and have just been denied long-term disability for the second time. Wondering if there's anything I can do.
How's that stress level?
Very high.
Seriously.
Very high. And so I'm going to jump on this because myself and a few members of our team, John, do specialize in both the employment law practice and the disability law practice. And this fits right within our wheelhouse. And so I want to start with this caller's information around being forced on a short-term disability leave. Your employer can't force you on a leave. That's not something that can actually be okay. And there's a process that your employer is supposed to engage in with you before it comes to the point where you've got to make some hard choices about your employment. But that choice comes between yourself and your doctors. It's between you and your doctors who decide whether or not you're capable of working. Short of that, your employer has a duty to accommodate you. And they have a duty to go through the process of accommodation with you. I find invariably that when employers are not experienced in dealing with people in this kind of situation, the easy answer is we're just going to push them off to the disability insurer so that this person is no longer our problem and we don't have to deal with the accommodation process. But the starting point is that duty by the employer. And when they breach that duty, they expose themselves to an employment claim, definitely. And then you go to the stage of the disability insurer. Then what? Well, then the disability insurer is going to look at this, and they're potentially going to do the same probing that the employer did, which is there a capacity to work? And if there is a capacity to work, then this isn't a disability issue, it's an employment one. The trouble is, though, John, where is this caller to turn to, right? And the challenge then becomes the medical information. That is why the disability claims have to be supported by your medical team, is because it's a medical decision. It's not the decision of the employer. It's not really even the decision of the disability insurer. If you're disabled and you can't work and your doctors are supporting that that's the case, then you are entitled to disability benefits. If you require accommodation and you've got some restrictions and limitations, then the swim lane, so to speak, is to pursue that accommodation with your employer. What do you think, James?
Well, you made a promise in the last segment. I certainly don't want to make a liar out of you, Tamar. So you said that we would talk about appeals, and we will.
Yeah.
So the caller mentioned that he's thinking about applying again for LTD. I assume he means appealing the denial of the LTD decision, and so now is as good an opportunity as any. The appeal, if you were to look in your policy, is nowhere to be found. It is not something that is required under the policy. It is, in fact, something that the insurance companies have created for a very specific purpose. Think about what happens when you're sent a denial letter. You've applied for long-term disability benefits. You're hopeful you're going to get approved. You're getting this letter that is saying, sorry, you're not, for whatever reason. Usually it's pretty vague and doesn't make a lot of sense. If they are to leave the letter like that, the first thing people are going to do is say, well, what do I do now? I better call a lawyer. So the insurance companies aren't stupid. They give you another alternative. They say, okay, well, we're sorry that your claim has been denied, but alas, there's hope. There's light at the end of the tunnel.
Throw you a bone.
All you need to do is send us any updated medical documents, and we'd be happy to hear your appeal. Well, guess what? That appeal isn't going to be heard by a judge or some independent arbitrator. It's going right back to the same people that made the decision to deny your benefits in the first place. And you should have no confidence whatsoever that they're going to come to a different conclusion based on the same information. Now, of course, if you happen to have substantially different medical information today than you had yesterday, if there is a new cancer diagnosis, yes,
maybe
appeal. And I would be shocked if the insurance company didn't at least strongly reconsider it, although it wouldn't shock me if they then still denied it. But nonetheless, that is one of the few exceptions where an appeal might actually work. But for the vast majority of people, an appeal is not going to go anywhere. Your insurance company is in business to make money. They make money by denying claims or cutting them off as soon as they can. And once they found a justification for doing so, it is very difficult to get them to change your mind unless there's a consequence. And the only way there can be a consequence is if you start a lawsuit, you start litigation, and so they know if they continue to act unreasonably, at the end of the day, they would have to go in front of a judge. Thankfully, just starting that process is in 99% of the cases enough to get them to the table and act reasonably.
Answer that phone call, huh? It is done. We'll move on to the Guide to Disability Benefits and Depression after the break, so continue to stick around. More of the Disability Law Show is on the way. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. Just to fill you in again, I'm John Scholes, your host, and with me, James Fireman, Tamar, Agopian from Samfiru, Tumarkin, LLP. Reach out anytime, on your own time, have that conversation. Phone number, 1-855-821-5900, help@disabilityrights.ca. We did mention the main topic, of course, for today, Guide to Disability Benefits and Depression. Got about 3 or 4 of these guys. You go back and forth. Tamar, take the first one.
Sure.
If you can't work because of your depression, you should apply for long-term disability benefits.
Absolutely.
Yep.
Absolutely. I mean, there's just no question about it. Insurers want to have you believe that mental health claims like depression are not valid disability claims. We say this so much, John, but it continues to happen. We not only see people who don't actually make that application, but we also see a lot of resistance from disability insurers when that application is made. But if you don't apply, you don't even get the opportunity or the right to then pursue your LTD benefits if the insurance company denies. So the starting point always has to be that application, whether it be short-term or long-term, if your doctors are supporting the disability. But I'm going to add one little nugget right out of the gates, which is you want to make sure that your application is fulsome. You want to include everything. So in all the ways that depression is impacting your day-to-day function, should be included in that initial form or documentation that you're sending to the insurance company. It's too easy for the doctors, John, to just simply, put one word, one sentence here and there and fill out those forms. And I get it. The medical system is overloaded. It's not that doctors have a ton of time to do an 8-page form, but you want to encourage then that your doctor include either clinical notes and records, or if it's not just your doctor supporting the disability claim, perhaps you've got a psychologist or a therapist or a social worker, include their support in that application information as well, so that the insurance company has everything. I describe this as spoon-feeding it to the adjusters who have zero experience in these kinds of claims. And so we want to see that best foot forward being put out there to the insurer when you make that application.
James, number 2 is yours. Make sure you have medical support of your disability along with detailed notes and documents. Like we often say, if it isn't written down, it doesn't exist. So make sure it's there.
Yeah, and this plays right into what Tamar was just talking about. So it is critical anytime you are applying for long-term disability, whether it's for a physical issue or a mental health issue, that you have support, medical support. And typically that's going to start with a family doctor. That's usually the first line of treatment, whatever your issues are. And from there, you branch out into whatever medical specialty is required based on your particular disability. Now, you may not be at the point when you're applying for disability benefits where you've actually gotten specialized mental health treatment, and that's perhaps a function of the mental health treatment opportunities and facilities across the country, frankly. But even if you're not at that point yet where you've been able to get treatment, you still want to make sure that you are going to your family doctor regularly and getting treatment from your family doctor. Family doctors are still trained in all specialties, at least to some extent, and almost all of them are capable of providing at least some level of mental health care for their patients as a first line of defense. And so you want to make sure that you're engaging your family doctor first and foremost, and any specialist, and that there are notes that are updated on a regular basis that are detailing the issues that Tamar was just talking about, the ways that your condition is limiting you, impacting you on a day-to-day basis.
Number 3, back to you, Tamar. If there is any delay in getting therapy because of a shortage of treatment providers, like James kind of alluded to there, look for alternatives while you're waiting. Makes sense, right?
It does make sense, and this is really acute right now in the post-COVID world. The treatment times, the wait times across the country, John, are long. longer than insurance companies would like because they get impatient, and they don't want to necessarily release benefits for months and months while you wait to see a psychiatrist or perhaps even a psychologist. But there are options, and as James said, your family doctor is a great starting point. There are free resources as well, group therapy options. Perhaps your employer has an EAP program that offers, even 12 sessions. Maximize those benefits, access those elements of treatment so that it is essentially a gap between the time that you're seeing your doctor and perhaps the wait time to see an actual mental health specialist. But this is critical because at the end of the day, it's what goes right back to what I said at the start. If you have support from multiple elements, from multiple places, that you're getting treatment, first of all, and that those treatment providers are supportive that you can't work as a result of your depression, it makes it that much better if the insurance company makes the silly decision either to deny you out of the gates or to deny you down the road because they think, well, we see this a lot, right, James? You can continue getting this treatment and go back to work, right? This is classic for insurance companies. And I think, again, it's a lack of understanding of how depression can actually really impact people and be, in fact, totally disabling.
What we were talking about, sorry, James, you want to go?
I just want to jump on that because I think it's important to point out that even though we are not where we were 15 or 20 years ago, people certainly have a much better and healthier understanding of mental health conditions and how they can really impact people. I would love to be able to tell you that that has wholly translated into the disability insurance world. It hasn't. Now, it's better than it was, but it's still not nearly where it ought to be. And part of that is insurance companies taking advantage of the lack of mental health care. And so if you are in the position where Tamar was just talking about, where you don't have the ability to go see a psychiatrist right away, the waiting list can be a year. I've seen 2 years.
Wow, come on.
Or you don't have a therapist because you're in a non-urban area and there's just one and they're already all booked up. What are you going to do? So Tamar said, yes, find all the free resources you can. Also, get referrals. Even if it's going to take 2 years, get on the waiting list. What you don't want is to give your insurance company an easy way out. An easy way to say, well, yeah, it's hard to find treatment, but what have you done? What steps have you taken? If you can say, well, I'm taking advantage of all of these free resources, I'm on the list to see this psychiatrist, I don't know when it's going to happen, but that's not my fault, and I'm seeing my family doctor on a regular basis, what else can I do? If the answer is nothing, then that's not an avenue they can use to deny your claim. So you want to make sure you've closed that off.
Guide to disability benefits and depression. That's what we're talking about on the show. Last one, I'll keep it with you, James, and that is if your LTD claim for depression is denied by the insurance company, talk to a disability lawyer immediately. Big time.
Yeah, absolutely. And so it's what I was just talking about, the way that mental health conditions are treated by insurance companies. You can go in with the expectation that it's going to be a more difficult path than it is for a physical condition. That's the reality of it, but that doesn't mean it's hopeless. I certainly have seen people with mental health issues be approved. I don't want to give the impression that it's an automatic denial. It's not, and some insurance companies are better than others. But even if you are denied, if there is support from your doctors, you have a family doctor that's supporting you should not be able to work because of a mental health condition, you have specialists, therapists that are supporting that as well, or even if you're just on the waiting list to see one, if your insurance company denies you, you very likely have a very solid basis to challenge that decision. And the only way to get what you're entitled to get the benefits that you've been paying into for years, is to hire a lawyer and to bring a disability claim, and that's exactly what we do.
Good stuff there, guys. We'll take a short break and we'll get into some email on the other side of that break, so stick around. The Disability Law Show continues. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Disability Law Show. A few minutes to go. The phone number anytime to reach James or Tamar when we're not doing the show, of course, 1-855-821-5900, help@disabilityrights.ca. That's the email address. That's where we're going, guys. It's going to be Stuart this time around. Writes in, says, guys, my wife suffered a stroke about 2 years ago, resulting in partial paralysis, which prevented her from working. She's made great progress in her health, but her neurologist says she isn't ready to go back to her job. The insurance company felt otherwise and cut her off LTD. Our first appeal failed. Saw that coming. Should we try again? I'm going to send this one to Tamar because James already ranted about appeals. We know exactly where he stands.
It's virtually the same rant, John, because, look, this really frustrates me.
I know.
Because you've got a specialist. The specialist neurologist is saying to the insurance company, this person is not capable of working. And the insurer has decided to deny the claim in their wisdom for whatever reason it might be. And it's frustrating because it's not in the policy. They're not transparent about what they do when you apply for this appeal, this so-called appeal. They're not even giving you a fair shake, but they're not telling you they're not giving you a fair shake. So I really do feel as though the cards are stacked against individuals like this, like Stuart, like his wife, when they're banging down the door and saying, hey, but our doctors are saying that she cannot return back to work. The easiest answer, and I mean it when I say this, is the legal claim. Why is it easy? Because A, we're going to do it all. We're going to take care of it. We will support Stuart and his wife through the whole process. It takes it out of the hands of the adjuster that's probably already said no once, likely to say no again. And we leverage things like the fact that the specialist has recommended that she not work. We leverage reputation and financial risks against the insurance company to get efficient results. And they can't ignore us, right, John? And this is the thing. And this is why the appeal process is really set to fail. All it does is that it continues to allow the insurance company to keep you in their process, as opposed to taking it out of their hands and allowing someone like us to help move that needle to get the compensation that Stuart and his wife are owed.
Plus the phone stops ringing once you guys take over, which is a wicked benefit.
For sure. Solid rant right there. Give it a 9 out of 10.
Not a bad rant, right?
Yeah. I do actually want to talk about one thing, though, because I think one of the advantages of having a show like this is that we can do nuance. We can talk a little bit more about it. What I am curious about is Stuart's talking about his wife's neurologist saying that she can't go back to her job. And I note that it's been about 2 years since her stroke. So I'm wondering whether this is an issue about the change of definition. Because at the change of definition, the test changes to whether or not you can go back to your own occupation versus any occupation. I'm not suggesting for a moment that Stuart's wife is capable of going back to anything. But I would also want to go back to the neurologist and clarify that and make sure that there is support there, that she can't go back to do any occupation. And I fully suspect that's going to be the case, that she's just going to have difficulty getting through a full day of work or perhaps even any work whatsoever. But whatever the case is, I still would want to get that clarified by the neurologist before we moved forward with it. And you have to be aware that there are these timelines within the claims process, and the 2-year mark is a critical one.
And the insurance company will be all over that. The change of definition, they'll be on top of that for sure, right?
Absolutely.
Yeah. Yeah.
Absolutely. We're parroting one another now. We're reading each other's brains. But right, John, because they set up the policy so that they can cut people off at that point. And so James is absolutely right. That's likely what's happened in this situation. And that's typically where we see people come to us. But you have to actually come to us. So please do give us a call. We're here to help.
And we are out of time, up against the wall, so we'll leave you that contact information to wrap up for the show today. Reach out to James or Tamar, 1-855-821-5900. That is help@disabilityrights.ca. And again, disabilityrights.ca. You want to find a radio station across the country and here in the GTA that carries our show as well. And we'll catch you next time. Thanks for tuning in right here to the Disability Law Show.